rise. The Court of Appeals Division 1 is now in session.
Thank you.
Please be seated. Good morning and welcome. So we are here today on our case number 1CACV180135, WALTZ Healing Center, Inc. versus Arizona Department of Health Services. So, Council, thank you for making the trip here. We appreciate your indulging us in this enterprise. As you know, each side's allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use for rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself. The cards that you see over there will reflect the total amount of time you have remaining, including what you might have decided to reserve. We are recording these proceedings, so we'd be grateful to you if, when you approach the podium, you'd give us the name, your name and the name of your client for the recording. We have reviewed the briefs carefully. We've looked at the record from the Superior Court and from the administrative proceedings, and we've read the transcript of the hearing that the ALJ held. We've also discussed the case in our conference among the three of us. So with that, you may proceed.
Good morning, and may it please the court. My name is Jeff Matura. I represent the appellant, which is WALTZ Healing Center. To the extent there is time left over after questions, I will try to reserve about 5 minutes for myself. If that's not possible based upon questions, that's okay too. This case addresses the following fundamental question, which is whether a regulatory agency, such as the Department of Health Services, can impose requirements on a third party that are not otherwise stated in its own regulatory language. I know you've reviewed the record, but as a starting point for my discussion today, I want to refer to the relevant regulatory language, which is the Arizona Administrative Code R9-17-304C6. And for simplicity going forward, I will likely drop the R9-17 and simply say 304C6. This is the regulatory construction that deals with applying for a dispensary registration certificate with the anticipation of opening a medical marijuana dispensary under the laws of the state of Arizona. The particular provision at issue here today is 304C6, which deals with the requirement to submit a letter from the local zoning department from the city or municipality where the applicant hopes to open a medical marijuana dispensary. C6, which is under the applying for a dispensary registration certificate section of the code, requires the applicant to provide confirmation of one of two things with respect to zoning. One is that there are no local zoning restrictions for the proposed location of the dispensary. The other option is to provide documentation that the dispensary's location is in compliance with any applicable local zoning restrictions. Now,
It says is.
Is in compliance.
And the statute also, the statute that the reg serves also says is in compliance, correct?
That's correct, Your Honor.
What does that mean in terms of time?
Well, this is the issue in this case. What does "is" mean, and what requirement is mandated in terms of time with respect to the zoning letter?
What did your letter say?
Our letter said it is in compliance.
And the letter was dated 4 years before the application.
That's correct, Your Honor.
Is it undisputed that the City of Tempe zoning regulations changed between 2012 and 2016?
They did change, Your Honor, but I don't believe that's the relevant analysis for that issue.
Well, I'm just wondering, though, how can we know if the zoning regulations have changed in the meantime? How can we know in 2016 that the location would still be in compliance as it was in 2012?
Yes, Your Honor. Two responses to that question. Number one, we have to understand how the regulations work in totality. We have regulations to apply for a dispensary registration certificate, which is what we're talking 304C6 in this case. But that's not the regulations that apply to open. That's just the regulations to get in the door, if you will. If you're in the door and you're accepted, you then have different regulations to comply with to actually open a dispensary, including obtaining a document called an approval to operate. That process to get an approval to operate requires you to submit zoning documentation for your actual location where you intend to operate.
A conditional use permit.
That's part of the process as well. There is no requirement in the regulations that the address, the proposed location that you submit to apply, needs to be the same location that you're actually going to open.
Well, Counsel, I might agree with the argument if we were talking about the application in 2012. But we're not talking about the application in 2012, we're talking about the application in 2016. So if you have to show that you are in compliance with the zoning, that may have been true in 12, but it's not necessarily true in 16.
Correct, Your Honor, but again, the regulations, the way they're written, the department wrote their regulations however they wanted to write them. They've separated the process into different steps. There's the requirements to apply. Our letter, I would suggest, meets the requirements to apply. It has the magic language the department wants. That is not to say that letter would be sufficient to open.
What if the letter were dated 1950?
That's a good question, Your Honor. And the department has taken the position in this case, the date of the letter is irrelevant. The department's argument, as I understand it in this case, is it's not the date of the letter that causes them concern, but rather it's whether the letter expired or not. So the date of letter, Your Honor, again, to apply, the date is irrelevant from our perspective.
How can that be if the regulation and the statute both use "is," the present tense, is in compliance?
Well, again, it's the difference between applying and opening.
Wait a minute, the regulation says is in compliance.
Correct.
So under your theory, you could once you get a letter, that letter is valid for eternity.
That's the way the regulations read.
Even if the city of Tempe passed a zoning ordinance that said, we are absolutely not going to have a medical marijuana dispensary at this location.
That's the way the regulations read. Our problem would
The letter
be
would not,
opening.
no, because the regulation says it has to be in compliance. And so you would knowingly present a letter that you know does not represent what is the current regulation for the city of Tempe.
That raises a few issues, Your Honor, if I may.
You may.
First of all, that's how the regulations read, Your Honor. There's a distinct difference between applying and opening. Our letter would not suffice to open a dispensary. We're not suggesting it would. And in your situation, we would have to go back to City of Tempe for location X, which is different than the one in our letter, to get approval.
So what if you applied you said a request to the city of Tempe and said, we would like to know about this location, and they sent you back a letter that said you would not be in compliance?
Then we are not going to be able to obtain our approval to operate from the Department of Health Services, and we will not be allowed to open.
Well, you wouldn't be allowed to open. I'm talking about at the application process.
Oh, I'm sorry, excuse me.
At the application process, you attached a letter that said, from the city of Tempe, that said you are not in compliance.
If that were the letter that we attached to the application, our application would not be substantially complete.
What's the difference if if the ordinance has changed, but you have an outdated letter, and you are not in compliance when you, that location is not in compliance when you apply.
Well, a few things, Your Honor. Number one, there's no evidence in the record that the change in the ordinance invalidated that particular location. That evidence
right.
isn't in the record. So we can't, I guess we could assume it, but it's not in the record. It's not evidence in the record. Second of all, Your Honor, we have to look also, I think, at what the Department of Health Services told WALTZ Healing Center. Because we know the process is that the applicant, such as WALTZ, applies, submits all the information required. The department then tells WALTZ, whether we have met their requirements. We received the email saying we've moved along the process. We are moving forward.
You're talking about the September 19th or October 4th?
Excuse me, thank you, Your Honor, let me clarify. You're right, there are two steps. Okay, let me break those down just to be clear. There is what's called a request for information, which is a letter from the department identifying any deficiencies in your application. Let's talk about that first. We received a request for information. The request for information made no mention whatsoever that our letter was expired, was not current, was anything else. What the request for information said is our letter is not on the Tempe letterhead, which it was. It says our letter is not signed, which it was. It says our letter doesn't have the address, which it did. The letter that we received from the Department of Health Services is as if they didn't read our letter, because it told us to provide something that we already provided. That was the first step. The next step is that we...
Hold on for a minute before we proceed from that. What the response on that on the September 19th email, what it did say is that it didn't say your letter, it just said you lacked a statement that there was no local zoning restrictions for the dispensary's location, or, and then it quoted, the dispensary's location is in compliance with any local zoning restrictions.
Yeah.
Isn't that a way of telling you didn't give us a current information?
The word current appears nowhere in the September 19th letter.
It is in compliance, says to me that it is in compliance.
What the department did is it quoted the language back to us from the regulation, word for word. And
it would have been nice. It would have been nice if the department had said, hey, your letter doesn't work.
Not only would it not have been nice, but there are 17 items on this letter, and during the administrative proceeding, the department admits there's no reason why there couldn't have been 18. And number 18 could have been your letter is not current. And then we would have had the ability to say, what is current? Is it 6 months? Is it 6 weeks? Is it 6 years?
So on October 4th, you did get that email.
Okay, thank you, Your Honor.
Did WALTZ respond to the October 4th email?
So on October 4th, we do get the email, and the email says, the information provided does not satisfy the request for information. Here's the key language, quote, please submit current local zoning, end quote. That was October 4th, and the email said, it was sent to us at about 11:30 in the morning, and it said you had to respond by 5 that evening. No response was provided because no time was able to provide.
So no response was provided. I didn't see any evidence that WALTZ offered in the record that it could have provided a current letter if it had had a few more hours or 10 days.
Yeah, my recollection, Your Honor, is Mr. Steve White, who was the representative for WALTZ at the hearing. He's also a licensed attorney in Arizona. My recollection, Your Honor, of course it would be in the transcript, is that he testified if he had more time, he would have contacted the city of Tempe. We don't know what the city of Tempe would have said.
That's right. So we don't know, there's no evidence in the record that WALTZ could have satisfied the requirement had it had another 10 days.
We don't know. We don't know. Again, our position is that the letter itself submitted met the words that the department said we had to give them.
Could WALTZ, or could Mr. White or someone else from WALTZ have picked up the phone and called the department after it received the September 19th request for information and say, hey, we gave you the letter.
Well,
why are you asking for more? Why are you asking for another letter? We gave you the letter.
Well, when talking about the request for information, that was responded to.
But my question is, if WALTZ was confused, I mean, what I hear you saying is there are ships passing in the night.
Well, I'm not
if
sure.
If WALTZ was confused, could someone from WALTZ have picked up the phone and contacted the department to ask them?
Yeah, I'm not sure it's ships passing in the night, Your Honor. What I view it a little bit differently. WALTZ submits its application. It receives a request for information from the department saying, these are the 17 items that you need to clarify going forward. A fair reading from WALTZ's perspective of this letter is it asked for information about this zoning letter that it already had.
So WALTZ was confused.
Well, I don't think it was confused. I think it says, okay, you received department 700 applications. This may be, you know.
Well, it was puzzled. It was puzzled by why the department was asking for a letter that it had already received.
And therefore resubmitted the letter.
Then could WALTZ have picked up the phone and asked the department, why are you asking for the letter? We sent you the letter.
I think they probably could have, Your Honor, certainly. Just as the department could have added number 18 on the list that says your letter is not current. Then we would have had the discussion with, presumably, would have had the discussion with the department that would have been, what does current mean?
It just seems odd for WALTZ to receive notice that the letter wasn't adequate, and all you do is submit it again. That doesn't really, I can't imagine how you would think that would help when they found the letter wasn't adequate.
From WALTZ's perspective in September of 2016, and my recollection is this was testified to during the underlying administrative proceeding, is that upon receipt of this letter, they cured all 17 items, and with respect to the 3 items, 8, 9, and 10 that dealt with the letter, they look at the letter, they looked at what the department was asking for, the letter contained that, and therefore resubmitted or re-referred the department to the same letter.
Why is WALTZ arguing that the letter didn't expire on its own terms, given that the letter stated 2 terms? It said it would expire within 60 days if WALTZ didn't submit an application, and would expire at the conclusion of the application process.
That's correct, Your Honor. I appreciate the question because I want to talk about the expiration issue. Expiration is, as a legal defense by the department, is something that comes up after WALTZ files the lawsuit. There's nothing in the record, and when I mean record here, I mean the correspondence between the department and WALTZ during the application process. There's nothing that discusses expiration. At most, we have a question about currentness. But in the 2 communications between the department and WALTZ, the request for information and the follow-up email the day before the allocation process, there's no mention of expiration. And again, that's an argument.
So letter that is not current has not expired?
I don't think that's the same, Your Honor. I don't think that's the same. Again, it's when we're dealing with the application process, the issue of currentness came up during that October 4th, 2016 email. What this has morphed into in the lawsuit is your letter expired. It's a nullity. It's as if we submitted a blank piece of paper. That's a different lens to view this issue through, in my opinion, Your Honor. And I see I have 5 minutes left, but I am more than happy to take those 5 minutes now if you have more questions.
You're good. Thank you.
Thank you.
Good morning. Thank you for your time considering this case, Your Honors. My name is Gregory Falls. I am with the Sherman and Howard Law Firm, and I am representing the Arizona Department of Health Services, the appellee in this case, the agency responsible for denying the WALTZ application. I believe it was Judge McMurdy asked counsel a question to the effect of whether it was appropriate for an applicant to file an application knowing that it did not have the proper zoning approval to go with that application. At least that's the way I paraphrased it. The statute actually requires a sworn statement that the property is in zoning compliance. Under the facts of this case, the department clearly could have denied the application for failure to meet that statutory requirement. That was not the reason for the denial, so that is really not an issue before the court right now. What really is before the court is a simple case that can be decided by answering one simple question. That question is, what is the validity of an expired government document? You think about it, it's commonly accepted as a matter of fact and law. Pardon me.
Did you tell WALTZ that their letter had expired?
Did not in those words say your letter has expired?
And
No.
why not, if that's what the reason is?
Yeah, let me jump right to that, because there appears to have been in the compassionate care case, which we cited throughout our briefs, and in this case, an attempt to confuse the process. And the process involves a two-stage consideration. The first stage of that is administrative approval. And if you think about this, 750 applications for a dispensary registration certificate. I piled some papers on the table here. Picture 750 of those in a room. The department has 5 days to consider those, determine whether they're sufficient or not, and issue notices to the applicants whether they're sufficient or not. 5 working days. So someone looks through that quickly and says, has the fee been paid? Is the property identified? Is there a property owner approval? Is there a zoning approval? 7 more items. Check off on a checkbox. Whatever items are missing goes into a system, an automated system. The automated system kicks out a notice that says, you're missing these items. That is a very cursory review, and it's a quick look. Does this document is it what it purports to be? In this case, we don't know, because the person who did it doesn't remember doing it, but we can surmise that the person looked and said, oh, this is a letter from the city that says zoning approval. Okay, great, checked off the box. Administrative approval was fine. No notice was given to WALTZ that they did not meet that requirement at the administrative approval stage. Then we get to substantive approval. Substantive approval is actually a more thorough review. Substantive approval is where someone sits down and says, what does this letter say? Is it for this property, for this applicant, for this time period, so forth and so on? Again, checking the box. Whatever boxes are not checked, a notice is issued. In this case, the person who reviewed this looked and said, wait a minute, we have a letter here that expired 4 years ago. We don't need to know whether the property was zoning approval compliant 4 years ago. We need to know whether the property is zoning approval compliant now.
So the agency said a notice to WALTZ that the letter had expired then?
It was obvious on the face to anyone with common sense that the letter had expired, yes.
But those words were not used.
Those words were not used, no.
Wouldn't it have been easier just to say, you gave us an expired letter, try again?
It would have been, yes, clearly it would have been. But what the department tried to do for all errors, not only this one, there were, 17, I think council said, in their application. What the department tried to do, rather than saying, you didn't get it right, do it over. The department tried to say, here is what we need from you to do it right. And so that was the language of the RFI. And if you look at the RFI doesn't say, hey, your letter doesn't cut it. The RFI says, we need from you 3 things.
But somebody who's made an application can simply look at that and think, oh, we may not have included our letter. So here, we're just going to put it back in, and here we go. I mean, if the department looks at a document and thinks that something's missing from that document, why don't they just tell them it's missing, it's expired, whatever the case may be?
Yeah, again, because of the volume, realistically, for someone to individually draft, first of all, the department's duty is not to counsel applicants on how to follow the law. That's something the applicants, in this case, this applicant had 2 sets of lawyers helping them do. So would it be easier to tell them exactly what to do? In a perfect world, I have to admit it would be. But really what the department is trying to do is to tell people, hey, you have failed to meet these requirements, in this case, zoning approval. Here's what you need to do to meet it. And then it is up to the applicant to meet it.
At this second review step, how many applicants were there existing?
I don't know the exact number, but of the 750 original applications, probably more than 700, I think, was the testimony presented in the record, made it through administrative approval, so they were being considered in more detail. And by more detail, I don't mean that somebody just read them. If it said, we have zoning approval, somebody might pick up the phone and call the city. Did you issue this letter? Does this property really have zoning approval? They might contact the property owner. There were many, many things that the department was doing. And in the process, there was a complaint in the briefs about how this email at the end was a second RFI, which it clearly was not. But in the process, the department had many people answering the phone. And one of you asked, couldn't you just pick up the phone and ask them? That could have happened. And if that question had been asked, someone would have pulled this application and they would have said, oh, yes, your letter is out of date. It's expired on its face. We need a current letter. We need a letter that says the property is compliant.
Is there, oh, I'm sorry.
No, you go.
Is there, so there's evidence in the record that after the September 19th email saying, we need this information, that if WALTZ had called the department could have given them, oh, it's been expired?
Yeah, not specifically in those words. The evidence in the record is that the department was responding to inquiries from applicants during the course of the process.
But no one said, oh, we would have fielded that question and specifically been able to tell.
That question was not asked in that way, no, Your Honor.
If the letter had not specified its expiration, okay? So imagine this letter that was just dated May of 2012, but didn't refer to expiring. Would that have satisfied the department's requirement?
It is. I don't know because of the facts are slightly different there, and here's how. The date of the letter alone would not have been something that the department would have said, sorry, letter's out of date, can't do it. If the letter did not have an express expiration provision, the fact that it was 4 years old may not have raised an issue. But as I mentioned earlier, the department also would check to determine whether representations made by applicants were valid.
So the department is not taking the position that a 4-year-old letter that says that a location is in compliance, the department is not taking the position that that doesn't suffice under the reg.
On its face, that is correct. Now, I think the evidence in this case, again, the department didn't have the burden of proving that the property was zoning compliant at any time, but I think the evidence in this case shows that the property was not zoning compliant, and here's why. It's circumstantial evidence, but here's why. We do have testimony in the record that Tempe changed its zoning regulations after the date of the letter.
Did the department know that at the time that it processed this application?
The department was aware of that during the processing of these applications, yes. If there had been no expiration date on the letter, the department probably would have asked Tempe, is this letter still valid? Have you changed your zoning? What have you? I don't know. That didn't happen here. The department didn't need to do that because the letter expired. But we do know that attorneys, WALTZ and its attorneys, were given notice that they needed to present a letter that says the property is zoning compliant, and they did not do that. They could have gone out and got a letter. They waited until the last day for responding to the RFI and did not submit a new letter. What did they do? And didn't call, didn't ask. What did they do? They submitted the old letter.
So I just want to make sure I understand. So the department's position is that the letter didn't suffice because it expired on its own terms. The department is not taking the position, as I understand it, that a 4-year-old letter doesn't suffice under the reg or the statute.
That is correct. Counsel is correct when he says there's nothing in the rules that says the letter has to be of a certain date. The department didn't look at letters and say, this one is 90 days, this one is 30 days, we're throwing out the old one. No, not at all. What the department did do was it looked at a letter, and again, as I started off, a government document on its face that says, this document expires on July 7, 2012. The department looked at that and said, okay, Tempe, your letter expired July 7, 2012, we'll accept that. It's no longer any good.
Well, but that's not what was communicated.
What, was that fact, the way I just stated it, communicated directly to the applicant? No, what the applicant was told, we need evidence that the property is in compliance with zoning regulations.
And if they reasonably but wrongly thought that their letter was in compliance, no one would have gotten anywhere because they would have done what they did and said, well, gee, I believe this letter is enough. They didn't tell, and they told me we need a letter, but I guess I didn't get it. We're sending out a copy.
Well, that's what they did, but it's unbelievable that anyone reading that letter thinks, especially knowing that Tempe has changed its zoning, that the man who signed it is not even in that position anymore, so he can't even make that representation anymore. It defies logic to think that you are applying for a license that will be extremely valuable, and you believe that a letter that on its face clearly says it expired a long time ago is still valid.
So the letter, so WALTZ resubmits the letter on October 3rd in response to the request for information, at least by my counting it.
I don't know the exact date, but they resubmitted the letter at the end of the RFI time period.
Okay.
October 3rd sounds about correct.
And the next morning, midday, the department sends an email to WALTZ saying, send us a confirmed current zoning. What was that all about? Where does that fit in the regulatory process, and why was that sent?
Yeah, there is no regulatory process that prescribes or allows for, or requires, let me put it this way, I think it allows the department to reach out to applicants informally, which is what that was, to try to help them meet the requirements necessary to apply. In a strict, perfect legal world, my view would be you file your application, and if it's not sufficient, it gets denied. The department has a little bit different view of how you do that. They go out of their way to help these people meet the requirements of statute and rule. So that is why they would answer the phone, send emails, essentially counsel applicants on how to do what it is they need to do. All of that was informal. None of it is required, but it is what happened with as many of the 750 applicants that chose to take advantage of that process.
Doesn't that raise the other issue that the WALTZ raises, and that is the notion that if the department is reaching out and helping certain people, but not reaching out and helping others, then you may have some equal protection arguments, as in they're helping their friends get these very valuable licenses.
Yeah, you would if that were the case. First of all, the department did not select who to reach out to based on relationships or anything like that. All inquiries were received and responded to the best that they could be, so there was no selection process there. If someone had been issued an RFI, like it happened in this case, and they failed to correct the RFI, the department would reach out to them and say, hey, you failed to correct it. Come on, this is your last chance. So again, I think you're referring to their equal protection argument, and equal protection says that not that everybody, not all 750 were treated the same, but that everybody among those 750 who failed to meet the RFI requirements was treated the same. I don't recall specifically what the record says about that, but it was a situation where on October 3rd or 4th, whenever it was, those that had failed to meet their RFI requirements and were in danger of missing the drawing got emails saying, hey, you're in danger, we still need your stuff. And in this case, we got nothing further, and that's why the application was denied. They, like every other applicant who failed to meet the requirements of the statute and the rules, they were denied. They were treated like every other applicant.
When was the equal protection argument raised?
When was that raised?
Yes.
I don't recall if that was raised in the administrative, well, it was raised in the administrative hearing because I remember that Mr. White testified that he was aware of other applicants who submitted expired zoning letters and were approved. When he was cross-examined on that topic, he was unable to identify by any description any other applicant whose expired zoning letter was sufficient. So but we deny that that occurred, but that was an argument at least that one of the witnesses raised in his testimony.
So there's no issue of waiver of that issue then?
Waiver of equal protection,
If it were raised, then it would not be waived, correct?
The waiver of equal protection argument, I don't think was waived. The argument that was waived was the argument that the department has taken inconsistent positions in other cases. That argument was not raised in the administrative hearing. We explained this a little bit in our briefs, but the inconsistent position argument gets back to what they did in the compassionate care case, and that is two stages in an applicant lifestyle. The one is to get the certificate. You must show that your property is zoning compliant to get a certificate. Some people apply for a bare strip of land. Once they get their certificate, they build out their dispensary, they do any number of things. That requires any number of government approvals, including things like special use permits and what have you. At the second part of that stage, you must then come back and get approval to operate. That requires, again, proof that not only that you're zoning compliant, but also that you have all the special licenses necessary to physically open the doors and start selling medical marijuana. That is the two-stage process. The department has never veered from the requirement that that process has two stages, and they are slightly different. But to the extent that WALTZ wants to make that argument, that is an argument that was waived because it was not raised in the administrative hearing below. Everyone who applied was required to prove that their property is in compliance with local zoning. That was something that was a decision made by the local municipalities. The department accepted that decision. If the local municipality said yes, then they met that requirement. If they said no or didn't say anything, then they did not meet that requirement.
If they have a letter, if the applicant gives a letter from the city of Tempe dated 1960 saying that the location is in compliance, would that suffice?
That would suffice to get to the stage of substantive review where then we would ask, you guys have a letter from 1960. It's possible, that's a little absurd because medical marijuana was not a concept, I don't think, that far back, but it's possible that a city established zoning in 1960 for a certain property and that zoning has not changed. And if
So what would be the department's response?
The
Would the department accept it and put it through to the lottery, to the drawing?
If that statement is accurate, yes. But again, verify. It would not be blindly accepted without verification that it is a truthful statement because the statute requires a sworn statement that it is in compliance.
Does the record tell us that the department picks up the phone and calls every local zoning authority to confirm that a letter is current?
Not in those words, but two of the department's witnesses testified that yes, they would contact the municipalities to make that determination. I see I've run out of time.
Well,
thank you.
So
I will answer your question.
So you're telling us that if the letter, well, I'm just kind of puzzled about this then. In this case, the letter was dated 2012. Absent the expiration language, would the department have picked up the phone and called the city of Tempe?
Yes, and that is in the record. I believe they actually did in this case to confirm that Tempe had changed their zoning.
It changed the zoning, but there's the evidence. Does the record show us whether the zoning that was current as of 2016 would have allowed this location?
I believe we attached that zoning evidence to our brief, and my view of the change was that Tempe limited the number of dispensaries and that number had already been reached or exceeded, so that it would not have been zoning compliant in 2016.
Thank you. Mr. Matura.
Thank you. It's clear that the department's position is that the date of the City of Tempe letter is not the proper analysis. Their position is they denied the application because that letter expired. I just want to refer back to where in any of the correspondence to the department ever tell WALTZ that was their basis for the denial. It's not in the request for admission, it's not in the email in October, and it's not in their denial letter. What better place to look for the basis for their denial that they told WALTZ than the actual denial letter? It's not in there. There's no mention of expiration at all in any of those three communications between the department and WALTZ.
I thought the denial letter said that that you hadn't proved that it was currently valid, that it was current.
Yeah, the denial letter, so the request for information identified 3 issues with respect to the letter. The denial letter then only focuses on one of those 3. It's item number 9 in the request for information. The denial letter says the basis for the denial is that WALTZ's letter did not include one of the following statements required by 304C6, which is there are no local zoning restrictions or the location is in compliance with any local zoning restrictions. A pure reading of WALTZ's letter contains that language. It did not, the denial letter.
Same language also says that that's expired.
Well, the letter, the letter says what it says. There's no denying that there's a paragraph in the letter that says it expires.
So your client submitted an expired letter.
That WALTZ submitted a letter that met the requirements the department set to apply, not to open, to apply. And again, it's 304 is to apply, but 306, 307 talk about changing the location once you get in the door. And 304 is to get in the door. And its letter had the required information. Now, if the department had wanted to, who has the burden here? Who has the obligation to clarify this issue? WALTZ submits the information. It receives a request for information that says, your letter's not in the letterhead, it's not signed, it doesn't have an address. Well, clearly it had all of those. So it sent it back and said, it does have exactly what you told us it needed to have.
Well, so if the letter had explicitly said this letter expires on X date, rather than the language it had, would your argument be the same that your letter was still valid?
If I understand, Judge, was your question if the letter had not contained the expiration language?
No, if it had, as I read the letter, it said it expires at the end of the application process.
Correct.
If it had instead stated a particular date,
Okay.
and that date is passed, would your argument still be, and the letter was still valid?
Yeah, our argument would be the same, Your Honor, and here's why. If it had a specific date of expiration, whatever the date was in the letter, the department still, given the facts of this case, never told WALTZ that was the problem.
But did you submit under Judge Howe's theory, if the letter had simply said, this is good until the end of 2012, and you could still submit that letter, even though you knew that you did not have a letter that stated there was current or valid zoning for your location?
We could, Your Honor, and here's why. Because as of the signature and execution of that letter, the information was valid. It's submitted to the department to meet the initial requirements to get in the door.
So once you get a letter from the City of Tempe, as I asked earlier,
Yeah.
that letter is valid in your opinion in perpetuity?
To apply.
To apply?
Not to open. And
So
if the
even-
department had a problem with that, they could have told us, you can't do that.
What if the letter had a giant null stamp on it?
Sure, a big red X or something like that.
Void.
Right, void.
Then-
Again, Your Honor, yes, it sounds absurd. I understand. I get that it sounds absurd. All 200 people in here think it's absurd. But
Should we ask for a show of hands?
No, I don't want to do that. I lose that show of hands. But that's the way the system is set up. We didn't set the rules. We're just trying to comply with the rules.
Now, and so you were, Waltz was expecting then that the department would contact the city of Tempe to follow up, to ask the city?
No, Your Honor, that's not what Waltz was expecting when they applied. What they were expecting when they applied, and I believe this is testified to by Mr. White at the administrative hearing, was this would go through the normal administrative and substantive review process, which it did. If there are any deficiencies identified related to the topic we're here to talk about today, the department would have told us, and it would have been dealt with and resolved. And if not, application would have been rejected.
How could it have been dealt with?
It would have been up to Waltz to go get whatever letter the department told them they had to get. That's what, and if they couldn't, and then if the department rejected the application and sent a denial letter that said, you did not resolve the problem we told you about, we don't have an argument, Your Honor. But that's a completely different set of facts. What we've been faced with is the department told us why it denied the application, and now we have arguments about expiration that was not the basis for the department's denial.
How can we reverse what the department did without a showing by Waltz that it could have obtained a letter in October of 2016 that the location would be consistent with zoning?
Your Honor, if I may really very quickly answer your question. Thank you.
Absolutely.
The time frame made that impossible. Do I wish we had more time back in October of 2016 to have had this conversation with the department and resolved this issue and created the evidence that we would need here today? Certainly, but remember the time frame. The email, when the first inkling of any issue, but it was currentness, not expiration, was October 4th. The allocation or the issuance of the dispensary registration certificates was October 6th. And we only had 5.5 hours on October 4th to try and solve this problem. It just wasn't possible.
But I'm looking for the date of the hearing. The hearing was in January of 2017, so 5 months later. How can we reverse without evidence that Waltz gathered within that 5 months to show the ALJ and the department that if Waltz had been informed of the problem, it could have given a current letter?
Your Honor, I think, respectfully, I don't think that's the basis for a reversal. I think the reversal that we request for is based upon the department being arbitrary in its denial, because it denied for a reason that, on its face, Waltz complied with.
All right.
Thank you. Thank you.
Thank you. Thank you to all the lawyers for your briefing and for your argument. We'll take the matter under advisement and issue a decision in due course. Now we will adjourn.